just follow the speaker. Dot. Are you a great group? Okay, we're going to kick off our afternoon program, but it seems like I always have something else to say, and I try not to. But I would like to recognize some more our students that we have in the audience this afternoon. Of course, you met a few of them this morning, but where are our students from the Summer Institute? Right there. Look at that. Okay, we have our case students. Where are our case students? Okay, I have an assignment for you. I want you to learn the answer, then I want you to come and tell me, not anyone else. And that assignment is, where is your dean? And when you learn that, come and tell me. Are any of you in my class this semester? No? Oh, gosh. Okay. All right, we have...
So the word is spreading, Jim.
The word got out, and by the time I get to class on Thursday, there won't be anybody signed up, will there? Okay, let's see. We met a few Syracuse students this morning. Where are they? They're out. Okay. Professor Crane, where are your students? Ah, I see. Okay. Our New York University students, where are you? I know we've got a few. Jennifer, where are your students? Oh, gosh, you've lost track. There, okay. There we go. Oh, they're up there. Come on. All right, great. And our Washington students, where are you? All right.
Layla.
Yeah, okay. Gosh. Oh, I forgot one, didn't I? Yeah, what about us? And our Allegheny College students, right over there. It's great to have you. Brian brought a great group up this year, and we're so pleased to have you. All right, let's move into this afternoon's program. And I am not going to say very much at all. Mark Drumble, your moderator, a member of our advisory committee for the dialogues from Washington and Lee University School of Law. Mark, it's all yours.
Great. All right, so this is a very exciting panel, and I'm really thrilled to be part of it. The topic now is changing times, new opportunities for international justice and accountability. I think it's particularly exciting that the Humanitarian Law Dialogues are picking up pictures of dialoguing about justice through multiple forms and multiple venues. And really the heart of our panel here today is to focus on what I would describe as the new, the novel, the innovative, something that's undiscovered and under-discussed, whether generally or also more specifically to the general topics that are raised at the Humanitarian Dialogues. Then, to me, novelty and innovation and newness can arise on multiple fronts. One front, of course, is in terms of the methods of justice. Another way to innovate is by thinking about challenges to overcoming impunity that take different forms. We can also diversify our conversations about where places of injustice may be, and we can energize conversations by looking at opportunities to do better in different ways, in different places, in different spaces, and by welcoming a much broader array of faces. And what I would ask is our panelists here today, which I've mentioned already, to use this as an opportunity to identify one or two such opportunities for entrepreneurial and creative thinking. I will very briefly introduce our distinguished panelists today in the order of speaking, and of course I encourage them when they open their remarks to offer perhaps a little bit more about their background and experience and how they come to some of these particular issues. Our first speaker will be Professor and formerly Dean Valerie Oosterveld from the University of Western Ontario Faculty of Law, where she also serves as Deputy Director of Western University's Center for Transitional Justice and Post-Conflict Reconstruction. Valerie has been one of the pioneers about thinking effectively and programmatically about addressing gender issues within international criminal justice. And I'm happy to say we went to law school together. So there you go. She will be followed on our panel by Brigadier General Mark Martins, who serves as the Chief Prosecutor of Military Commissions in Washington, D.C. Prior to this assignment, Brigadier General Martins was deployed to Afghanistan, where he served as the interim commander and then deputy commander of Joint Task Force 435 and as commander of the Rule of Law Field Force. Also of interest, I noted in his bio, is he is a Rhodes Scholar, and we'll leave it at that. He will be followed by Justice Duncan Gaswaga, who has an absolutely fascinating judicial background. He's currently a judge of the International Crimes Division of the High Court of the Republic of Uganda and a fellow of the Commonwealth Judicial Education Institute. In his capacity of a judge on the International Crimes Division, he is positioning himself judicially at the intersection and forefront of a variety of some of the most complicated issues of transitional justice. Amnesty, accountability, trial, definitions of war crimes and crimes against humanity, and as we discussed on our chat over, a real opportunity to try to operationalize international justice at the national level. And of great fascination in his particular background is that he had had previous experience in dealing with issues of piracy also, not personally, but at the judicial level. So another fantastic opportunity. Our last two speakers, I will take much less time in introducing since they're well known to all of us. Our fourth speaker will be David Crane, Professor of Practice at Syracuse University College of Law and one of the founding beating hearts of the dialogues themselves. And our last speaker, who we also had the joy to hear last night, is Robert Petit, who has a distinguished and varied legal career in international criminal justice in a variety of institutions, and now is doing what might be one of the most important future steps in our particular field of accountability, namely thinking about this operationally at the national level. Each speaker will have up to 15 minutes. It'll give us lots of time afterwards for questions, answers, commentary, reflection, and rumination. Valerie.
Thank you very much, Mark. Now, Mark said that normally I research and speak in the area of sexual and gender-based violence, and I'm not going to talk to you about that today. I'm actually going to talk to you about Canada's Truth and Reconciliation Commission. And I'm doing that while in Canada, the Truth and Reconciliation Commission is very well known. Outside of Canada, it's not necessarily very well known. So let me give you the facts on why it was created. It was created to deal with the treatment of Indigenous children in something called residential schools. Residential schools for Indigenous children began in Canada in the 1870s. These were government-funded, church-run schools, and they were set up with a very specific goal. First of all, to remove and isolate Indigenous children from the influence of their homes, families, traditions, and cultures. And secondly, to assimilate them into the European Christian dominant culture in Canada. And these assumptions were based, these directions were based on the assumption at the time that Indigenous cultures and spiritual beliefs were inferior and unequal. and residential schools were specifically tasked, and this is an infamous phrase now in Canada, to kill the Indian in the child. These objectives were actually stated by Canada's first Prime Minister in Parliament in the 1800s, and were reiterated in Parliament as late as 1969. Over 130 residential schools were located across Canada. Most of the schools closed in the 1970s, but the last school closed in 1996, which is shockingly recent. From the 1870s until 1996, more than 150,000 First Nations, Métis, and Inuit children were taken from their families and placed in these boarding schools, which were intentionally placed far away from their homes, intentionally so their family could never travel and see them and interrupt the assimilation process. In 1920, under the Indian Act, it became mandatory for every Indigenous child in Canada to attend a residential school and illegal for them to attend any other kind of school in Canada. There are more than 80,000 survivors of residential schools living in Canada today. Residential schools provided an inferior education, often only to the level of grade 5, even though the students stayed in all the way till the end of high school, and were focused on training them for manual labor in agriculture or light industry or domestic work like laundry and sewing. You can imagine that these schools created massive generational impacts. Social problems like PTSD, alcoholism, substance abuse, and suicide were passed from generation to generation because of the break within the Indigenous traditions, cultures, and families. Parents were not allowed to pass their cultures down to their children, and the children grew up with no experience of a nurturing family life. And indeed, they weren't allowed, brothers and sisters were not allowed to interact with each other. While some former students had positive experiences and told the Truth and Reconciliation Commission about them, many, many more suffered neglect and abuse. And in fact, the Truth Commission identified emotional and psychological abuse as being absolutely constant, physical abuse as absolutely common and used as punishment, and sexual abuse was very common. These abuses were compounded by overcrowding, poor sanitation, and severely inadequate food and health care, resulting in a shockingly high death toll of these children. Many of the children were buried in places and their families never knew where they were buried. In the 1990s and 2000s, former residential school survivors decided to take the federal government to court, as well as the churches, Roman Catholic, Anglican, United, and Presbyterian. Their cases led in 2006 to the Indian Residential Schools Settlement Agreement. While part of that agreement was related to financial compensation for these experiences, another part of the agreement was to create a Truth and Reconciliation Commission, which is what I'm talking about today. The former students insisted upon the creation of a TRC because they did not want their stories to be lost because they were settling out of court. They wanted them put on the historical record. The TRC began operation in 2008, immediately after Canada's Prime Minister issued an apology on behalf of the government to Indigenous peoples for the creation and running of the residential schools. The TRC heard over 6,000 witnesses, and it operated between 2008 and 2015. In 2012, it issued an interim report called They Came to Take the Children, and in 2015 issued a multi-volume final report. The multi-volume final report clearly identified that Canada had committed genocide through the residential schools policy, and it defined cultural genocide. The TRC report had 94 calls to action. These calls to action related to everything in Canadian society. It related to what governments could do, but also what individuals, corporations, public institutions, etc. could do. Of these recommendations, there were 17 that were law-related, and they were put in a special section titled Justice. And it was very important for the TRC to deal with justice issues because of the role law played in facilitating and carrying out the residential school system in Canada. I'm going to focus on one particular recommendation today, and that's action item 28. And this is what it said. We call upon law schools in Canada to require all law students to take a course in Aboriginal people and the law, which includes the history and legacy of residential schools, the United Nations Declaration on the Rights of Indigenous Peoples, treaties and Aboriginal rights, Indigenous law, and Aboriginal Crown, in other words, the federal government, relations. This will require skills-based training in intercultural competency, conflict resolution, human rights, and anti-racism. The Truth and Reconciliation Commissioners recommended this because of the role law schools play in creating the foundation of knowledge for those who go on to practice law, however they may practice law. And saw that if the law students could be taught early, so to speak, about the history of Canada and the role law played in residential schools, as well as providing intercultural awareness, that this could then continue onwards once the students become lawyers and they could carry that into the practice of law. This call to action with respect to law schools led to quite a bit of soul searching and a lot of debate in law schools across Canada. There are 22 law schools in Canada, and there were 22 very different discussions across Canada about what to do. For any of you who work in academic institutions, this won't be a surprise to you that there were a range of positions, and the discussions were long and complex and very psychological as well as theory-based and whatnot. But in the end, the law schools came to different approaches. And I can tell you that the debates on how to implement, actually the debates were, first of all, should we implement this call to action? And secondly, if as a law school we decide that yes, we should, because they're not mandatory, they're recommendations, if we should, how should we do it? The recommendation is for mandatory courses, mandatory intercultural awareness of all students. But the debates within the law schools were, well, should it be mandatory or should it be optional? Because there's the debate over if you make it mandatory, then you may undermine the very thing you're trying to build up. Students will tune out, they might not care, they might kind of glaze over this. So let me tell you what my law school decided after quite a bit of soul searching and discussion. We updated and reinforced a module that all first-year students must take. So this is the mandatory part. They must take an Indigenous law module in Introduction to Law in the Legal System. We created a partnership with a local area First Nation. And that First Nation hosted something called Indigenous Law Boot Camp. For 3 days, students and faculty who wished to go went for 3 days and learned about the Indigenous law as practiced in that particular area, Anishinaabe law. We hosted something called Western Law Reads, where everyone who wanted to be involved read a particular book on Indigenous law in Canada, and then we discussed it and debated it. And we did an audit of all of our courses and determined which ones could be beefed up in terms of reference to Indigenous law, whether it's international Indigenous law or domestic Indigenous law. And lastly, we implemented more outreach measures. So we created a free law school admission test course. And any of you who are in the academic law school environment know that these courses can be very expensive. We created a free version for Indigenous students, and we also sought applications from those students. Other law schools have done very different things. On the far end of the spectrum is the University of Victoria, which created a joint JD/JID degree. The JID degree is a law degree in Indigenous law. So you can get this law degree jointly. And that is kind of the most extreme step taken by a law school. They also do things, and many law schools now do the boot camp that we did in Indigenous law. This law school also created an Indigenous law research unit. Lakehead University is another law school in Canada, and it has a very interesting approach where it has mandatory courses, 3 sets of mandatory courses for its students. I should mention that Lakehead University is in Northern Ontario, in an area with many, many Indigenous reserves. So there are a number of Indigenous law students there, as well as a number of Indigenous law professors. So it's, in a way, not surprising. They have a semester-long course called Indigenous Legal Traditions, which is mandatory. They have another course called Aboriginal Perspectives, which is an experiential learning course. And in their second year, all students must take a full year course on Aboriginal peoples and the law. University of Ottawa created an Indigenous law stream within its JD common law curriculum, and this is optional. So students can opt to take this particular stream. On the mandatory side, it changed its tort law course to be called Torts Managitoon. Managitoon is an local Indigenous name for resolving disputes that are like torts, and it's an intensive course that that 20 students take at the beginning of their first year, and it has Anishinaabe, Haudenosaunee, Dene, and Métis law, as well as Canadian common law altogether. University of Ottawa also has an elder in residence. Very first law school in Canada have an Indigenous elder in residence from a local area First Nation. And this person helps to inform the curriculum, inform the research, and work with the students on Indigenous law issues. And I will end by saying that these sorts of initiatives happening within law schools are just a microcosm, because this call to action is only one of over 90 calls to action. All across Canada, these discussions are being had. So within my larger university, there are many other calls to action that apply to educational institutions. You can imagine, of course, because this relates to residential schools and educational institutions. So within my university, an entire strategic plan has been created. There's a hiring program. We, as a law school, will be hiring an Indigenous law professor this fall to start next year. But all across the university, every faculty is looking to do the same thing. And all across Canada, faculties are looking to do the same thing. And then there are also symbolic steps that have been taken. Some universities have been doing this for years. Others are introducing it only just now, such as my university, where symbolically the universities are acknowledging that they are located on Indigenous territory. So at every significant gathering that we have at my university, we recognize that the University of Western Ontario is situated on the grounds of the Attawandaran, or neutral peoples, as well as the Algonquin and Haudenosaunee peoples, then Anishinaabe peoples, and then Lenape peoples. So that's symbolic recognition that is meant to decolonize the Canadian relationship with Indigenous peoples. And I'll end there.
Thank you. In fact, you stopped 30 seconds early.
Fantastic.
So Mark, you don't get to keep that time, but you get to start 30 seconds early.
Thank you, Professor. I am grateful to Dave Crane, to old friends Jim and Pam Johnson, to Michael Newton, Michael Scharf, and Mark Agrast for welcoming me and the United States Office of Military Commissions to participate in this dialogue. I have to tell you, for a simple infantry soldier, such as I am, and a son of second-generation immigrants to the United States, to be here, experiencing with such immediacy the spirit of Chautauqua, spirit of Justice Robert Jackson, of Geneva, of Nuremberg, through the books and speakers we've had, of The Hague, and then with such diverse applications as Cambodia, former Yugoslavia, Lebanon, Rwanda. It could be a bit daunting for a simple infantryman, but I'm encouraged to add a voice to the dialogue by international humanitarian law itself. I mean, a revered psalm, Old Testament psalm, and many texts of civilization say that a just law gives wisdom to the simple. Now, Jim Johnson would say, hey, I need a lot more than that. Of fulfilling the prosecution function under the Military Commissions Act of 2009. This is a piece of legislation that was broadly supported in the United States Congress and signed into law by President Obama. We are built around a military justice system. Department of Defense in the United States is very proud to be subordinated to the rule of law, to fulfill the rule of law, and part of that is to enforce the rule of law through our courts-martial system as necessary. The Military Commissions Act has the law of war and the law, international humanitarian law, in our first section, in our last sections, and in many of the sections in between. The definition of hostilities is a key jurisdictional component of our practice. Our jurisdiction is limited to situations of hostilities, and each of our offenses has to have taken place in the context of and associated with hostilities, and that's an international test. Those familiar with the Tadic case in the International Criminal Tribunal for the former Yugoslavia, those familiar with Elihu Root, we heard about him from Mark Agrest at lunch. This has to be a protracted armed conflict, as Elihu Root said in the context of the Philippine armed conflict that we were involved with over 100 years ago. And then the Tadic case also spoke of this test in the former Yugoslavia. It has to be protracted violence of a nature, scope, intensity such that a nation must use its military to defend itself. And that's what all three branches of our government say we are in with Al-Qaeda and associated forces. We have an authorization for the use of force. We understand this is not how the world necessarily sees it, but it's certainly the law of our land. So under the Military Commissions Act, there is a convening authority who is, under the Uniform Code of Military Justice, a commander. Under the Military Commissions Act, the convening authority is Secretary of Defense Mattis. He delegates that to a senior U.S. official. Now it's Harvey Rishikoff is the convening authority of military commissions. I'm a prosecutor. Our office brings charges. We must investigate them. We must ensure that we can prove the offenses. And then we forward them to the convening authority, who at this point serves something of a grand jury function, a testing of the charges to ensure they state an offense under the applicable law, that the accused is the one who did it. And if he finds that, he will then refer the case to a military commission, which is a board of officers. It's a board of 5 or more officers when the case is not subject to capital punishment. It's got to be at least 12 when the case is a capital case. At that point, a trial ensues that, many of you will, almost all of you will recognize. The accused is presumed innocent. The prosecution must prove guilt beyond a reasonable doubt. The accused is entitled to notice of charges, specific charges in a language he or she understands, the right to counsel, choice of counsel, and in a capital case, so-called learned counsel, capitally qualified counsel at government expense, the right to presence, protection against self-incrimination, protection against the use of statements that obtained as a result of torture or cruel, inhuman, or degrading treatment. And the standard for admissibility of a statement is that the statement is voluntary under a totality of the circumstances. The right to witnesses, so compulsory process, the state going out and making sure they can get witnesses, and certainly the ability to confront the witnesses that I and the prosecutors will bring. Exculpatory evidence, so discovery. In our law, it's the Brady and Giglio discovery as well. So exculpatory, I have to turn over that which undermines my case. That's an ethical responsibility and a legal responsibility of prosecutors. The right to an impartial decision maker, So these are people who have no connection to the case and are subject to examination and challenge by opposing counsel. Not challenge for cause to be granted liberally, peremptory challenge as well, where you don't have to state your reason. The right protection against double jeopardy, so you can't be charged and tried for the same offense, and the right to represent yourself. If you do that knowingly, voluntarily, and intelligently, you don't have to take the lawyer that's been assigned to you, and the right to appeal. Our first level of appeal is a military civilian court called the United States Court of Military Commission Review. That's Article I court, so a legislative organ created by the legislature. So the first court is a civilian court, and then by petition for writ of certiorari to the United States Supreme Court. So those are the rights the accused gets in our system. We currently have 7 arraigned accused, and let me say, the accused are presumed innocent. I'm a sitting prosecutor. I will certainly stay within the bounds here of my obligations. These are alleged offenses, but we have in arraignment the 5 alleged 9/11 co-accused: Khalid Sheikh Mohammed, Ramzi bin al-Sheba, Khalad bin Atash, Mustafa al-Hassawi, and Ali Abdul Aziz Ali, alleged to have committed the 9/11 attacks. Abdul Rahim al-Nashri, the alleged bomber of the USS Cole in October of 2000. And then Hadi al-Iraqi, who is an Iraqi, alleged to have led field forces of al-Qaeda in Afghanistan following 9/11, when international forces got to Afghanistan. We've got 2 other cases where the individuals have been found guilty and are in various states of post-trial process short of sentencing. One of them will actually be sentencing in about a week. And then there are 3 cases that are very active on appeal, including one, Ali al-Balul, which is just decided last summer by the United States Court of Appeals for the District of Columbia Circuit, and we're not sure if the Supreme Court's going to grant certiorari or not upon petition from the accused in that case, or the convicted accused, Balul. Balul was convicted of his role as essentially al-Qaeda's pre-9/11 suicide recruiter. Made a very well-known propaganda video, The State of the Ummah, and it had pictures of the USS Cole, and it was something used to indoctrinate, among others, the 9/11 suicide attackers. So that's our, we have a rather large office with that many active cases, wonderful public servants from across our government. At any given time, 6 to 8 career prosecutors from the Department of Justice, that's the National Security Division of the DOJ, as well as field U.S. attorneys' offices, judge advocates from all services, Army, Air Force, Marine Corps, Navy, and then wonderful paralegal specialists from all services and civilians as well, analysts, 20 to 25 full-time Federal Bureau of Investigation agents, and then many DOD investigative law enforcement officers from the Army Criminal Investigation Division, Naval Criminal Investigation Service, Air Force Office of Special Investigations, and others. We have defense counsel who were quite formidable. Some of you may know Jim Harrington is defending Ramzi bin al-Sheba. He's a Buffalo longtime defender. Cheryl Borman, capital defender out of Illinois. Rick Kamen, who defends Abdul Rahim al-Nashri, is one of the most accomplished capital defense attorneys in Indiana, and others. And it is not a harmonious thing, our trials. It is a clash, as you would expect. And so in the spirit of this panel, one idea, we're a national forum, right? So one idea for advancing the efforts of this group to end impunity and to go after it wherever it lives is to use national forums, as well as the esteemed international forums we've been hearing about, to incorporate norms and rules of international law. We cite them every day in our proceedings, and to bring people back to those essential principles and those basics. Thank you.
Oh, thank you, General. You're finished. All right. All right. We got an extra 5 minutes now for questions at the end. You can't take his 5 minutes. Our next speaker will be Judge Gaswaga. We look forward to hearing from you, sir.
Thank you very much. I would like also to thank the organizers of this event for the invitation. And back to the theme, I have no doubt that these are changing times, and a lot of things are happening, especially in the area of international humanitarian law. We've already had, this morning, we look at the manner in which offenses are committed, the technology that is applied, the legal regime, for instance, modes of liability, and so on. So a lot is changing. And these changes, I feel they present some challenges as well as opportunities. I want to look at it as a form of opportunities. In this way, in Uganda, we have the War Crimes Division, where I work with 6 other judges, although 2 have already retired, I think, last month. They're just completing their work. And this War Crimes Division is supposed to deal with international crimes as well, transnational and international crimes. Now, how do we say it's, and how do I look at it as an opportunity? Before I do that, I want to look at how it came about. You may have read about, I'm sure most of you have read about the war in Uganda that has lasted over 20 years between the government of Uganda and the Lord's Resistance Army. It was agreed in Juba, in order to end this war, that some things should be done. One of them being that a war crimes chamber should be set up. And those people who have committed grave breaches of international humanitarian law, human rights, should be dealt with and prosecuted. Already, one person is before the ICC. A group of them, the topmost leaders, are supposed to appear before the ICC, and others are supposed to appear before this chamber. At that time, the chamber was called the War Crimes Chamber, but the name changed a few years later to International Crimes Division. I don't know what is in a name anyway, but what I know is that it was as a result of a resolution that was written by the Chief Justice of Uganda, because the International Crimes Division is a division of the High Court of Uganda. So we are talking about a domestic court, a national court that is going to deal with international and transnational crimes. As a result, this court took on 7 judges. It has a registrar, it has a prosecution unit, although that prosecution unit falls under the DPP, the Director of Public Prosecutions of Uganda. And again, under that particular division unit, we also have investigators. These are also attached to the Uganda police. So we do not have foreigners, so to speak, working in this whole system, although we have some that do advise. Now, the war between the government of Uganda and the LRA left so many people dead, a lot of destruction of property, and so many other crimes committed. They needed a way to address all these crimes. How should these atrocities be dealt with? It was felt that by establishing the War Crimes Division, we would get an answer. How is it operating right now? We have registered about 13 cases. I only heard that last week, I think 2 more have come in. I wasn't there. But 13 cases, and one of them is purely a case of a war crimes case. And that is where our main interest lies. But when the mandate was enlarged in 2011, we also included the cases of piracy, human trafficking, terrorism, and we've concluded 2 cases of terrorism. Those have been a little bit easy, but the war crimes case has proved to be a problem. It was, I will speak about it later on. Let me first look at these other ones. The terrorism cases were a bit easy because we had most of the witnesses there. They were not that expensive, and we managed to hear the evidence quickly and conclude them. But with regard to the war crimes trial, that is the case of Koyelo, it became very difficult for us to conclude, and right now, I will say we are at the pre-trial level after all these years, because when he was arrested and placed in detention, that is 2009, he decided to apply for amnesty. This was because there was a law that had been enacted in Uganda to give amnesty to some of the people that had participated in the LRA war. So they would be forgiven if they applied, and without them actually giving the details of what they did, as long as they admitted they had committed some crimes and they are ready to give up rebellion. Now, that has caused other problems in the Koyelo case. I want to end with the Koyelo case, and I will come back to that when I'm discussing it. Now, so this division has no permanent judges. The judges that work there work elsewhere as well. Reason being, we have very few judges, no other facilitation that you would think of, and yet the government wants people to be prosecuted, those that participated and committed atrocities in the LRA war, but at the same time, a lot of resources are needed, and I don't think they are ready to give those resources as of now. The other reason is that because of the Amnesty Act, and particularly Section 3, some people, I should say, and these are complaints because I've been down to the area where the offenses were committed, they believe that some people who should have been prosecuted are not being prosecuted, and they're not going to be prosecuted because they've already been given amnesty. This also carries with it a lot of problems, some of which I will not go into as of today. Now, we have, the prosecution has brought in one case in particular of Koyelo, and that case of Koyelo, there is an application of international law as well as domestic law, because the laws which are supposed to apply, were supposed to apply before now what I will call the ICD, as I've told you, the name has changed, are laws of Uganda. We have the Constitution, the Geneva Convention Act, the ICC Act, which we've domesticated, of course, and applying it with the necessary modifications here and there, the Terrorism Act, and so on and so on. The prosecution decided to bring 12 counts in their indictment against Koyelo. Later on, when Koyelo had unsuccessfully applied for amnesty, the prosecution decided that they should continue with the prosecution, with the trial, and amended the indictment and added 53 other offenses. Now, the problem is that most of the offenses are brought under international law, as well as, and the others are brought under our domestic law, the penal code. That would include, murder, destruction of property, that is under the international. You see, I'm also being very careful when I'm talking about the Koyelo case because I'm one of the judges that are going to decide it. So what I say here, I don't want it to be heard somewhere else and what I say here, I should be responsible for it and I shouldn't get into, say, the merits and so on. But those are decisions. I'm trying to say what I feel is going to raise some issues. And already the defense has intimated that they will be raising certain objections to the indictment, which is yet to be confirmed by the pre-trial chamber very soon. Now, on top of that, we feel that the ICD should be able to deal with these crimes, including international crimes. But there are going to be objections. I've already intimated. I'm trying to be careful. I don't know how I should put it. It's giving me a little bit of a problem. But definitely there are going to be objections. The issue I'm trying to put here across is that the law applicable is an issue for the chambers or for the division. How do you bring international law into the domestic jurisdiction? But we shall deal with that question when the time comes. The ICD faces numerous problems. And my coming here, I feel that I will also have interactions with quite a number of you to be able to find some solutions. One of them being that in the cases which we've done, we have no witness protection program. It's giving us a lot of problems. Even on the ground where the offenses were committed, that's in the war crimes trial, the Koyelo case. Some people will come and they don't fear, they will tell the judge that we will not come to testify unless we are protected. You see, offenses were committed in a particular society. These people were living, were neighbors, living with each other, and they know exactly who did what and how. But they will not come to testify unless they are assured of protection. The other is that we have our rules, which were adopted recently, rules of procedure and evidence, where we decided that we should copy and borrow a leaf from some of the international criminal courts and other jurisdictions to help us. So this is a domestic court, yes, but given the nature of the cases that it's going to deal with, we need to have some special procedures. Now, witnesses want to participate and the rules do provide for their participation, but the mechanism is also another very, very big challenge, already even at pre-trial level. Back to the witness protection program, the few cases we have concluded, for instance, one in the terrorism case, where some people were killed when they were watching the World Cup in Uganda in 3 different areas. We were given assurances, again, by people who are supposed to testify that we will not come. So that's how some of the people managed to escape liability. And the others, where at least we had people coming in, we managed to get some evidence. But for this particular trial, the war crimes trial, I won't tell you that we are worried. We have a bill yet to be tabled before Parliament since 2012. It has not yet been tabled. How do we handle this? What we've done also, we've managed to get some of the things that are in the bill because we do not know the reasons why the bill is not being tabled. But you know, these cases involve a lot of politics. Sometimes you may not even be aware. So we've picked some bits and placed them in the rules of procedure and evidence, where we just come up with some arrangements as a court to be able to protect some witnesses. But we can't offer much. I'm sorry, this may sound like I'm reading from the book of Lamentations, but we are here for justice, and I really want to borrow a lot from you. As you may also, I have just a few minutes left. As you also know, I'm sure many of you have read about this court. We are trying to do our best, and we are not ready to give up. Recently, they almost closed down the court saying, well, when we look at other divisions, they produce a lot of judgments. But for you, one whole year, you've produced 1 judgment. And it was true. But how do we go about that? Of course, these cases are so demanding, there's a lot that is needed. And that case, which we concluded, had 84 witnesses, some of them being ferried from so many countries and so on. And it went down at a cost of over 500 million Uganda shillings. So they were looking at us, 1 judgment, 1 year, and then all the other divisions of land, commercial, they're doing a lot of, churning out a lot of judgments. How do we go about that? I've already had some interactions with some people, and I could see. Chair, may I use the 5 minutes that my neighbor left me? Yeah.
You already used some of them, so you can use 3 of them. How about that? But that's it.
So, for me, I look at it. Look, the ICD is a very, very good opportunity where we should be able to deal with international, transnational crimes within a domestic setting. And it's the first one in the region. And many people really come around trying to see what we are doing. Others want also to establish such courts. But we are facing all these problems. And I've just hinted at just a few, as you can see. There's just a lot. If I talk about this division, it can take me a whole day. I want to end at that note by asking you to join us in this struggle so that we can look at international, justice and accountability and bring all these people that are involved to book. We don't let them just roam the streets. We don't want to encourage impunity, because if that court fails, that will be the end of it all. We will have authenticated actually impunity, and the other people that want to borrow from us will not be able to do so. It's unfortunate the time is very little. I want to leave it at that. Thank you.
Thank you. Following our speaking order as presented, David.
Well, thank you, Mark. And again, it's a real pleasure to talk to his good friends every year as we go through the dialogues. I'm really heartened to see a lot of students here. When we were putting together the dialogues, one of the key aspects of the dialogues was student involvement. So again, you're welcome, and we're just glad to have you among us. I've been sitting here listening to some very fascinating ideas and domestic solutions to national challenges from Canada, from the United States, as well as from Uganda. I'm going to shift this a little bit and kind of put us a little bit back at the international level and some interesting alternatives as we approach the issues regarding Syria. You know, we live in a very kaleidoscopic world. I am a child of the Cold War, and I thought that that was a pretty crazy time. But I've never seen a world more challenged since the Cuban Missile Crisis. We have shifting power structures. Old world alliances that we relied upon in the Cold War are challenged, weakened, and questioned. We have a multitude of dirty little wars around the world. No one seems to be following any of the laws of armed conflict. International criminal law is being questioned and challenged and seems to be wavering because of these geopolitical challenges that we face. And of course, the bright red thread of international criminal law, as you have heard me say many times, is politics with a small p. And right in the middle of all of this is the tragedy that was and is Syria. Because again, of the fact that in order to create some type of justice mechanism for the victims of these atrocities, we have to have that all-important political support, a political will, a political desire to do something about that. I know that morally and personally we're horrified by all of this, and the world community individually and in groups is horrified by this. There's a great interest of doing something, but because of the geopolitical checkmate that is going on between various powers and the current situation in Syria, there's little to be done. Well, there is something to be done, and in this past year, actually this past 7 or 8 months, a very significant new organization has been created, which I think augurs well potentially for the future. Now, I'm not going to get into the Syrian tragedy. I've been involved in this issue since the very beginning in March of 2011. And through the Syrian Accountability Project, I've been working on a conflict map, a crime-based matrix, a major incident index which analyzes and summarizes and picks out from a 9,000-page crime-based matrix the key issues and the key possible crimes that could be prosecuted by a future domestic, regional, or international prosecutor. And then we also have sample indictments for all of those who bear the greatest responsibility of all of the now 13 warring factions that are moving in and about that region. But really, over the past 6 years that I've been dealing with this, among several of you here and many colleagues in the United Nations in Geneva, there's really been no real movement towards some type of justice mechanism. It's just stalling. And as a co-author of the Caesar report and briefing the UN Security Council, where I'm talking to them and showing those horrific photos behind me, even that did not move the Security Council, even though everyone in the Security Council but for 2 countries voted to do something about that. We are still politically checkmated. Over the past couple of years, I've been involved with a semi-official or unofficial group of ambassadors in the UN where we've been just talking about these issues and looking for ways of how we're going to be able to be ready someday to deal with the tragedy. And I personally feel that that isn't going to be for another 5, perhaps 10 years from now. But I was getting a little frustrated, and sitting around with a group of the ambassadors, I told them, here's an idea that I would like to proffer. This is back in August of 2016, is why don't we create a Syrian Accountability Center? And they all kind of looked at me, and I said, well, let's chat about that. We have a lot of non-government organizations. I head one of them that are doing some great work. Some of them are doing excellent work based on the experience of the individuals who are running those, where we're collecting a great deal of data, some of which could be information, but certainly most of it is not criminal information that can be converted into evidence. And that's a huge challenge in this day and age of social media, where we have petabytes of data coming out of Syria, to the point of where somewhere in there the evidence is buried. It's almost like a needle in a haystack, trying to find verifiable, useful evidence to prosecute those who commit these crimes against humanity and war crimes. But there's no standardized approach to it. The Syrian Accountability Project has a standard process that we use. When I was chief prosecutor for the International Tribunal in Sierra Leone, the Special Court for Sierra Leone, but we don't have a unified official office to be able to take all of this data and with professionals in the office begin to actually create turn this data into evidence. So I was talking among this group of ambassadors, and I was telling them this, and I think that I told them that we need to establish a centralized official United Nations office. I called it the Syrian Accountability Center at the time, and this group was chaired by Ambassador Christian Bonavester and Ambassador Alia Altani from Qatar. And we began to kind of shape and mold that idea over the fall, and it went from a very easily recognizable name of Syrian Accountability Project to, it'll take me about a minute to actually give the official name for it, the International Independent Impartial Mechanism for ... I was fine with that because really the idea is, and it is now, that we are going to be able to move all of this data by all the NGOs and all of the other people doing work and be able to give it to this official United Nations office, and they will begin to do official work where someday a domestic, regional, or international prosecutor can turn to this office now and be assured that it has been put together in a way that it is evidence and not just petabytes of data. So I think that that's a fascinating beginning. In December, late December actually, of 2016, the United Nations General Assembly, we chose not to go to the UN Security Council for obvious reasons. It would still be in the dustbin of history. The General Assembly, in an extraordinary assembly, voted 105 to 0, with obviously some abstentions, to create the International Independent Impartial Mechanism for Syria, just to put it in an understandable way, and directed that the Secretary General, within 45 days, created terms of reference for this new office. And working together with some great folks in Geneva, we came up with those terms of reference. And now we have a head of an office of the International Independent Mechanism, which is coming together. And I think that that is a very important step forward, because we're finding, and we all know this, particularly those of us that have been in this business for quite a while, that we have these dirty little wars, we have these war crimes, crimes against humanity, but we don't have the political conditions by which the world can do something about that. Yet the crimes continue, the evidence begins to disappear. And over a period of time, and like in Syria, over a period of 5 or 6 years, the challenges really start to mount related to whether we can create a case against individuals committing war crimes and crimes against humanity. So I think that the International Independent Impartial Mechanism, I still like to call it the Syrian Accountability Center myself, but I think it's a great beta test for what I would proffer to all of us, those of us who can influence this, a more of a global accountability system by which we have an office in Geneva that begins to start gathering evidence officially and appropriately in all of these dirty little wars that are going on, and put it in a way that it can be cared for and gathered, so that when the world 2, 3, 5 years from now decides to do something about that, then the Global Accountability Center, or whatever we would call that, another very long word, or a title, or what have you, we'd be able to turn to it and say, look, the issue that took place in the South Sudan, could we have all of your evidence on South Sudan? And it had been gathered as the conflict was ongoing, or certainly just shortly after that. What I'm offering is just new ideas, new thinking about that. Now that could be then turned over to the International Criminal Court, for example, who is challenged by all of the things that our colleague talked about, and that's just the reality. So this would be a neutral center gathering appropriate evidence that has the appropriate foundation and reliability that can be used in court, and that could be turned over to the International Criminal Court, could be turned over to a regional court or another international tribunal, or a domestic prosecutor when a decision is made 1, 2, 3, 5, 10 years down the line that maybe perhaps we should do something about it. We have an office that can actually go to. But I think that the independent mechanism for Syria, I think, is a good beta test for this idea of now getting this evidence to a place where someday the Security Council, the Secretary General, and the General Assembly can be assured that, okay, we're going to do something about Syria, and then they can turn to an office that they know has done something official, appropriate, headed by extremely experienced individuals. And what's neat about all of this is we were beginning to put this together, you know, just 10 years ago, but certainly 20 years ago, we didn't have anybody that ever done this before, or very few. Now, as we say in basketball, we got a deep bench. We've got a lot of very experienced chief prosecutors, trial counsel, registrars, chief of investigations, what have you. And I think that then we can bring them together to start building those crime-based matrices and conflict maps and gathering all the evidence in proper chains of custody, so that when we do decide to do something, if ever, we can be assured that we can, as we used to say in my office, put bad guys in jail. Thank you.
Great. Thank you so much, David. And our last presenter is Robert, and then we'll have time for Q&A.
Thank you. And first of all, thanks again to the Dialogues for inviting me here. I've been coming here since off and on from the very first one in 2006, and it's always a joy to be here. Of course, I came here because of my international work, but currently I'm a senior counsel and team leader with the War Crimes Office of the Canadian Department of Justice. And at the risk of exceeding allowable Canadian content, I am going to talk to you a little bit about Canada's war crimes program. And because Mark has asked us to talk about what is sometimes maybe under-discussed in this fight against impunity. And one of the things that I think needs to be talked about a little bit more is the role, the fundamentally important role of states in discharging their own obligation, either as a member of the ICC or simply as, as a moral construct, in the fight against impunity. I think, in a very humble Canadian way, I think Canada could serve as one of the models how to do that. A little bit of history. In the 80s, following a series of newspaper articles, a National Commission of Inquiry was created and concluded that potentially thousands of Nazi war criminals had made their way into Canada after World War II when were living peacefully and undisturbed. They had, of course, by then acquired Canadian citizenship and built lives. Following that report and obviously the public outcry that followed, Canada created the War Crimes Program with the stated motto that Canada would not be a safe haven for people who commit these types of crimes and manage to find their way into our country. The way we initially went about it is that it was essentially at the very beginning just DOJ. We initiated a couple of prosecutions under what was then our statute, the criminal code. We had crimes against humanity and genocide and war crimes as part of our criminal code. Initiated a couple of 3 cases, I think. One of which, the most well-known, Finta, went all the way to the Supreme Court. But first made a stop in the Ontario Court of Appeal where Louise Arbour was sitting and the final judgment basically ruled upon the threshold that the Crown had to prove for intent for some of these crimes, and basically rendered our disposition, our statutes inoperable. The burden that was, as the court interpreted it anyways, made it impossible for us, essentially, to pursue criminal prosecution under that statute at the time. So what we did is basically reorient our program then on civil remedy. By that I mean, as I said, most of these people were then, well, for the most part anyways, law-abiding Canadian citizen, having obtained citizenship. We undertook several revocation of citizenship cases. Obviously, most of these people had come as refugees to Canada and then gained citizenship. Now, one of the grounds of inadmissibility as a refugee, and for those who don't know, all members of the convention, all states are bound to give assistance to refugees, and you will have a ground if you're under threat of persecution in your own country, and you will then be granted refugee status. However, one of the inadmissibility, one of the reasons you cannot be given refugee status, even if you fear persecution in your home country, is that you yourself were responsible for war crimes, crimes against humanity, or genocide. In other words, you can't commit the crime, lose the fight, make your way somewhere else, and then hope to gain from it a status in that country. And lo and behold, most of these former Nazis had forgotten to mention in their applications that they had committed, or been responsible for these crimes. So what happens then is that it gives us a ground to go against, to revoke their citizenship for fraud, having in a misleading manner obtained their citizenship or their status initially. And we did that. We went after several what we call World War II cases. And believe it or not, there is still one active World War II case. We are still trying to revoke the citizenship of Mr. Oberlander, an individual who, maybe not coincidentally, is a wealthy builder in Ontario, and there has been several actions in court since I think we were in primary school to attempt to revoke his citizenship. That, I think, concludes our current World War II inventory. Although I have to tell you that when we did have a few active cases, the RCMP had a monitoring device called a proof of life call. So they would actually call every year, once a year, our subject and say, "Are you alive? Thank you." So case still open. So that was our bread and butter for quite a while, was these World War II cases, until 2004, essentially, when we adopted the War Crimes Act. That came about during the movement for universal jurisdiction and the creation of the ICC and the Rome Statute. Canada was very much involved in all the negotiations leading up to the Rome Statute and the creation of the court, as I think most of you know. And during that time, obviously, mentalities and priorities, political priorities, followed within the country, so that once the court in 1998, when the Rome Statute was signed, we worked on that legislation, and in 2004 we adopted the War Crimes Act. And if I'm not mistaken, we were the first country to integrate into our laws the Rome Statute. Interestingly enough, Senegal was the first country to deposit its instruments with the court, if I'm not mistaken, right back at the hotel after the Rome Statute was signed or enacted. With that, we focused on modern war crimes. And you see the air quotes? Just in case you don't remember, the Rwandan genocide occurred 23 years ago. And that's modern for us. And you can well imagine all the implication that has on our faculties. But so the War Crimes Act was created, and basically the war crimes now expanded to be an integrated model with 4 partners. We have the Department of Justice, which is us, the War Crimes Section. We have the Royal Canadian Mounted Police, the RCMP, which is our national law enforcement agency. We have what used to be Canadian Immigration and Citizenship, which is now Immigration, Refugee, and Citizenship Canada. Yeah, that's it. I'm missing one. No? CBSA, I said, right? CBSA, sorry, which is our border agency, the people you meet when you come to Canada. The four partners basically have their own jurisdiction, their own roles to play into this. For example, the RCMP, being the law enforcement arm, has sole jurisdiction to conduct criminal investigation. And we have each our own role into this. And the way essentially it works, when a case, our case comes from different streams, basically. Most of them come through the immigration stream. Somebody will come to Canada, manage to get in, and somebody in their paperwork will notice a red flag of some kind. For example, when a person will say that they were not ever a member of their own armed forces, when we know that at the time somebody of his age should have been in the armed forces. Obviously, you hope that these red flags are caught when they're making their application abroad, but sometimes that's not always possible, because a lot of times, leaving aside the people who are now walking across from the United States, the people who go to point of entries at the border, normally from the US, are assessed in the US, they cannot come in, and normally you can't get your ticket and come in here if you don't have a proper visa, but it happens. People will show up at the airport, the passport is now in the bin in the airplane, and they will declare refugee status and tell us a story. Another way that we have is denunciations. People from their own community will point the finger in different ways, and we've had several of those. We have several cases where we came from assistance requests from tribunals. They'd like to come to Canada and interview somebody who knows something. Generally, it's because he knows something, and having it committed himself or at least been party to the offense. That's usually, or media, and of course NGOs, being very active in Canada as well, bringing these cases to our attention. If the person is still under consideration for refugee status or has refugee status, then that person will be dealt by CBSA under our immigration stream. And eventually, if the case is founded, will be deported to his country or another country willing to take him or her. If the person has obtained citizenship, we can't deport a Canadian. We have to revoke, first of all, the citizenship of that person. Again, establishing that that person has taken part or has been complicit or has committed himself. And obviously had committed fraud while obtaining his status or her status. It's an action in federal court. It's a civil action. The threshold for evidence is lower than a criminal process, but we still have to prove that that person was involved. And because of the nature of the allegation, judges and the jurisprudence is to the effect that even though it is a civil remedy, we have to bring forth a very solid case before a judge will conclude, obviously, that that person has participated and therefore participated and then lied about it during his process. We haven't brought one case where somebody has told us and he still came in. In some cases where the person is not deportable for whatever reason, or the offense occurred after that person became a Canadian citizen, then the remedy would be a criminal prosecution. We have done so far 4 cases of modern revocation. And in those cases of modern revocation, it is my office, DOJ, who has the lead. We conduct the case from investigation, analysis of the initial allegation, to the end of the litigation process. We go, lawyers, analysts, paralegal, we go find the evidence, find the witnesses, interview them, get our affidavits, come back, make our statement of claim, build a case, litigate, etc. If it is a criminal investigation, as I said, the RCMP has jurisdiction, so we provide advice. Some kind of Chinese wall, if you want, so that the person who decides to initiate prosecution and who conducts prosecution is not involved during the investigation. That's why we advise, and if the case does go to prosecution, we pass the case for the actual litigation to our Crown Prosecution Service, or they could not call that anymore. Anyways, the prosecutor and members of our office, consuls of our office, are part of the team that assists in court. We have done 4 revocation cases, modern revocation cases, our office, and we have done 2 criminal prosecutions so far. 2 Rwandan cases, one Munyaneza, an individual who was convicted of several counts of genocide and crimes against humanity, and who interestingly was one of my subjects in 1996 when I joined the ICTR. Was part of one of our 4 suspects that we're supposed to investigate. And 2014, he's found guilty by the Supreme Court. The other one, Mungwarere, was acquitted, and 4 modern cases. The challenges are incredible, especially in terms of criminal investigations and getting that level of evidence, thousands of miles away, 26, 23 years after the facts. And it costs a lot of money, millions of dollars for one case. So we are facing the same challenge, albeit in a different manner than most of the courts. But we are part of the government's budget line items. We are a formal section, and I think hopefully we will not only continue but grow as part of Canada's commitment for the fight against impunity. Thank you.
Great. Let's thank all of our speakers. But we're not leaving because we have about, I'd say, 15 minutes or so for questions and comments. So I've been quite firm in managing time, so please ask questions or else I'll feel sad.
We didn't even have a safe word.
Leila, here, please. Oh, hey, that would be so much easier. Yeah.
So, quick question for Valerie, and then a question for General Martins. Valerie, I'm wondering if you can speak to any pushback that there may have been in Canada. You described sort of what happened, and I just wonder if there was any political opposition to what happened. And for General Martins, I haven't been following the Guantanamo cases that, because I assume you're talking about the cases in Guantanamo, right?
Yes.
And so I haven't been following them that closely, but my recollection is that the profound jurisdictional issues are still there, and the ones that I'm thinking of are these actually war crimes, or is this all terrorism, and should it not be prosecuted in federal court rather than in front of the military commission? And how are you dealing with the issue of torture with respect to the detainees who are being prosecuted right now? So those are my questions.
Just 1 second. And Samantha, did you have a question for after? You sure? Okay.
Thank you, Leila. So at the high political level, in terms of political parties, no, there was no opposition. And in fact, when the TRC report was issued in December of 2015, the Prime Minister said, we commit as a federal government to implement all of the recommendations that we can that relate to the federal government. And he was then joined by all of the other political parties saying we commit to the same thing. However, there's a difference between the high politics and ingrained racism across Canada. The residential school system could not have happened if there wasn't racism that stemmed from colonial settlement times through to today. So it's been quite a process in trying to have this discussion across Canada and then seeing that racism arise in different circumstances. I only talked about the law school part of it. There are many, many other parts of it, including the fact that the commission called for an inquiry into missing and murdered Indigenous women, which was announced and is going on by the federal government. But the fact that so many Indigenous women could go missing and go murdered without people really noticing shows that in our criminal justice system there's a severe problem. And to tackle that, at the same time, racism has to be tackled. So it's going to be a long process, but there are some good, positive discussions going on.
Thank you, Professor Sadat. You asked such simple questions here. On the jurisdictional issue, Professor refers to a debate over whether conspiracy can be tried in a military commission. So the latest is the Balul case that I mentioned was affirmed. The conviction of Balul was affirmed at the United States Court of Appeals for the District of Columbia Circuit last year, 5-3. En banc DC Circuit found that Balul was properly convicted of conspiracy. Complicated opinion, fragmented, but a clear majority ruled that he was properly convicted. We talked about joint criminal enterprise this morning, and this is something that bedevils in many ways, right? International criminal tribunals, but also law of war tribunals in national forums. But the upshot, essentially, of the 5 judges who joined was that Balul was properly convicted of conspiracy because he had personally and knowingly committed overt acts in furtherance of an agreement to commit war crimes. And this was clear on the record. Was it a perfect trial? No. I mean, there very, very rarely is a perfect trial, but the judges found that he was properly convicted. It did figure into the judgment, Professor, that Balul forfeited a lot of his rights at trial, did not confront a lot of the evidence that came in, and this caused them to use a plain error standard of review. So it's important not to take too much from this, and we don't. And so all of the current cases, we are charging individuals with essentially completed conspiracy. I mean, something very kindred to a joint criminal enterprise. Conspiracy is essentially a mode of liability. It's a theory of liability to get to a completed attack. We're proving attacking civilians. We're going to be proving murder. We're going to be proving terrorism, that actually happened. We're not to the left of boom. We're beyond boom. And this is a lot less controversial in the history of the international law of armed conflict. You asked about why can't federal courts do this. The simple answer, in something of a dodge, is it's against the law in the United States. I mean, we don't have consensus to bring Guantanamo detainees to the United States. That's been the law of our land since 2010. If we're going to do a trial, we're going to do it under the military commission system. That's the law. More fully, the federal prosecutors who work with me every day and I agree that there is a category of cases that is best brought in a military commission. We have rules of evidence. There's a slightly broader aperture for the admissibility of hearsay. It's got to be probative, reliable, lawfully obtained. Witness has to be unavailable, but this is not unusual in a war or in situations of armed conflict. And then statements have to be voluntary. This goes to your third point about torture. Statements have to be voluntary, but they don't have to be Mirandized. And these make a difference. They can be overplayed, they can be demagogued, but they make a difference in an important category of cases. And although my federal prosecutors, sisters and brothers, I applaud them. I want every case that goes after impunity to be prosecuted. But they can't handle everything. And commissions can handle a narrow but important jurisdiction. And then on torture, I mentioned our law is that no statement obtained as a result of torture, and not just torture, but also cruel, inhuman, and degrading treatment that falls short of the definition of torture is admissible. And the standard for admissibility of a statement is that it's voluntary. More practically, the defense counsel are receiving thousands and thousands of pages under our classified information procedures of information about their client's detention. And this has been a big source of the litigation since 2014. We've been working 7 days a week in order to provide the judge, judges in each of these cases where it applies, the original information from the Central Intelligence Agency's former rendition detention interrogation program, give them the original information. He looks at the original and a substitute that protects genuine sources and methods that continue to be protecting people and provide the defense the information they're entitled to. And that's an important, accountability mechanism of this sharply adversarial process. It's not going to satisfy everybody that what we're doing is fair, but it's going to be as transparent as possible, and it's going to be sharply adversarial, and it happens to be the process that our legal system has said we're going to do this by. On transparency, which is another important aspect of sort of implementing the questions you mentioned, 60 different news organizations cover this. We have proceedings transmitted back to the United States by closed circuit television. It's not televised, but if you go to an extension of the courtroom that the judge has approved in the Washington, D.C. area, you can watch these proceedings. Nearly same-day transcripts, sometimes it takes a little more than a day, to be put online, www.mc.mil, and it allows people to take note of the proceedings. So, there are criticisms galore of things, but it happens to be a system that is accountable, that's sharply adversarial, and that attempts to apply the law.
Jim, do we have time for one or two more? One more.
Where is it?
Where does he fit in terms of, we have big fish, quote unquote, being tried at ICC, the long one. We have also little fish being given amnesty to come out of the bush and live peacefully in their communities, to give up their weapons and to come out and to stop, the abductions activity of the LRA, et cetera, in exchange for amnesty, essentially. So where does Aquila fit in terms of the impact of his trial in the Watkins case? So thank you very much.
Hey, 2 minutes. 3 minutes.
Oh yes, I can speak very briefly, even though I'm deeply saddened about Burundi. We've all been in this business a long time, and Burundi's been an open sore for all the time that we've been in modern international criminal law. And at the end of the day, Burundi versus Syria, it deals with that bright red thread of politics. There's a political will. There is no political will to do anything about Burundi, period. And right now, as far as any type of justice mechanism creation for Syria, even though there's a lot of interest and concern, there's no international political will to create a domestic, regional, or international tribunal. So that's why the independent mechanism was set up. Essentially, it's an office of a prosecutor by another name. We don't say it, but we all wink at each other. And so what we're doing is we are building a case against those who are committing war crimes and crimes against humanity in Syria, and we'll be doing that until it's time to hand that case over to a real OTP, or it'll just be a transfer. And that's why I'm very interested in possibly having just a centralized global accountability center where this stuff is just done routinely, sanctioned by the United Nations, and they just they build these dossiers and hand it over to a domestic or a regional or international prosecutor someday. But let's just see how the independent mechanism goes. I'm excited about it. People don't really realize how different this has shifted the paradigm. We've always just seen tragedies, and then all of a sudden we build a court around it and we go out and put bad guys in jail. Now we can't do that anymore. There's real challenges to that. So let's continue trying to get something done through something like an independent mechanism.
Judge, you've come the furthest to be with us today, and you have the final word.
Thank you. The short answer to your question is that I cannot tell you exactly where Koyero fits in, because the court has already pronounced itself on this matter. And for that case, it's the Constitutional Court and the Supreme Court. But that is for the record. Now, I want to say that the application of the Amnesty Act of 2000 has caused a little bit of controversy here and there, and probably that's one of the reasons why you are asking. Koyero, I don't want to look at him as a small fish when I look at other people that actually were granted amnesty. Of course, those with the greatest responsibility, the top commanders, were taken to ICC, but Koyero is one of those ones that are supposed to be tried in the ICD. Now, there are people within his category, also I would call them top commanders, who are within actually his own circumstances and in detention, who were granted amnesty. But for him, they did not grant him. And I hinted on this matter when I was making my presentation. I said he applied and he did not get it. On the very first day of his trial, he went to the Constitutional Court, and the lawyers raised it. And they went to the Constitutional Court agreed with them. The Attorney General, representing the DPP, appealed to the Supreme Court, and the Supreme Court reversed the decision of the Constitutional Court and said he should be tried. Now, if I went into it, it's very long, but it is all in, they played about with Section 2 and Section 3 of that act. And Section 3, Subsection 1 and Subsection 2, where Koyero falls under Subsection 2 if you're already in detention. And so that is now where Koyero fits in. If you want to know my own opinion, because I cannot overrule the other courts, that we can have a discussion later on, because I can see we are time bad. But I can give you my own opinion. But that is the official position. The courts have ruled, and that is it. No appeal. Thank you.
Let's thank everyone.
The great thing about the dialogues are that these discussions can be carried on into the evening and at the reception and at the follow-on reception. And so I would just like to remind you that those who are joining us for dinner at the hotel tonight, which is the people that are staying at the hotel plus a few others, there will be a 6 o'clock reception on the porch. And so please join us. That's a nice formal reception that the hotel is putting on for us. And of course, I remind the case students and others that at about 9:30, we will have also an informal reception on the porches, and unfortunately, you can listen to your dean sing and play his guitar. And Layla, the best part of the evening, and she helps it along greatly, believe me. But Layla, I believe your students showed up, so you're off the hook. And I did not recognize the Vanderbilt students. Where are they? Okay, your students are here. All right. We will, of course, pick up tomorrow morning at the Presbyterian House for the year in review. The prosecutors will draft their declaration at this time. But now, we're trying to get ahead on next year's dialogues. We're getting a jump start on next year's dialogues, on the proceedings for the dialogues. So all of you that have been a panelist or have spoken and will be featured in the proceedings next year, Mark's going to catch you and give you one of the release forms now. And so if you would please fill that out, give it back to Mark, to Molly, to me, before you depart, so that we have a jump on that for next year. Thank you. Now, I'm going to invite everybody who's not a student and who's not a prosecutor to leave, because this next session is for the students and the prosecutors. And so the shuttle is here to take you back to the hotel. The students, I invite you to come down to the first few rows, and this is your one-on-one time with the prosecutors.
You mean international prosecutors?
Do I need to sign?
2 days today.
29th, I think.
Here, hold on.
No, 28. No, no, 28. It's my wife's birthday, actually.
Excuse me.
All right. You're making us work for this thing?
Rivera, you're gonna have to put in. Rivera, you gotta put in your name.
Oh,
You know what I mean? Over your shoulder.
what was it?
New. I just put new initiatives. What's the date today?
28.
Three-quarters of them.
Great idea, Mark. Actually.
Good.
I start.
Again.
We've already started the introduction. Why don't you just do
All right, good. Hi, how are you? So I'm Fabrizio Guariglia. I'm the Director of Prosecutions in the Office of the Prosecutor of the ICC. I was born and raised in Buenos Aires, Argentina. I got my law degree there. I did a PhD in Germany when I was still young and bright. After I was an attorney in the Argentine Federal Ministry of Justice, I was involved in international criminal law matters. I was involved in the drafting of the Rome Statute. And then I was recruited by the ACTY, where I met my brother-in-arms, Norman Farrow, a number of years ago. He also looked bright and young at the time. And from there, I moved to the ICC, and I've been there ever since. So that's me.
One more introduction.
Mohammed too.
I'm Mohammed Bandura. I come from Sierra Leone. It's my country of birth. I work for the Residual Court for Sierra Leone. I'm the prosecution legal advisor and also the evidence officer in that office. So the Residual Court for Sierra Leone, as you all may know, is the court which succeeded the Special Court for Sierra Leone. And the Special Court was set up to try and prosecute those who were responsible for those very serious crimes. In Sierra Leone, there was a civil war there several years ago. So now that we're done with that trial, we have a number of persons who have been convicted and they're now in jail. The residual court, amongst other things, has business of supervising the sentences of these convicted prisoners. And amongst other things also, we respond to requests for information from national prosecuting authorities all over the world if they think that we have information which is relevant to any domestic prosecution that they ask us, and we provide it. So those are the things I do. I got my education in Sierra Leone. In later years, I did some postgraduate studies in the UK. I joined the court in 2002, and I have I've worked with the previous prosecutors of the court here, Mr. Crane and Mr. Rapp. I'm representing the current prosecutor, Brenda Holly. She's not here. She was the prosecutor who was in office when the court closed, and she continued on in the residual phase. Thank you.
And Mohammed was one of the openers of the Charles Taylor case, the president who's now in jail in Britain for 50 years.
Oh, okay. Oh, I didn't realize you had it. Hi, my name is Robert Petit. I'm from Montreal, Canada. So, contrary to Norm, I have a real hockey team to root for. I started my career as a crown attorney, a district attorney, or not sure exactly what level I would be here. But then in 1996, I went to Kigali, Rwanda, to work for the Office of the Prosecutor there for three and a half years. I went there to Kosovo, came back to Canada, joined the war crime section of Canada, of the Department of Justice. And I've been there, but in the interim, I've held other positions. I've been a prosecutor with the Serious Crimes Unit in East Timor, a senior trial attorney with the Sierra Leone Special Court, and I was the first international co-prosecutor for the Cambodian court, the Khmer Rouge Tribunal, where Nick is now. So, and I'm now, as I said, back at the war crime section.
Hi, my name is Nick Kumchin. I was a DA in Los Angeles for 20 years. In the last 17 years in various international tribunals where I've probably crossed paths with everyone here. And currently in Cambodia, at the Extraordinary Chambers Courts in Cambodia.
Hi, I'm Kevin Hughes. I'm a legal and political advisor to the prosecutor of the ICTY and the MICT, as we call it. I'm American, obviously. Before my current job, I was the senior legal officer to the appeals chamber of the Special Court for Sierra Leone in the Charles Taylor appeal, where I helped the judges work on that appeal and make sure that we got it done within the year we had. Before that, I was a senior international legal officer at the War Crimes Chamber in Bosnia and Herzegovina in Sarajevo, which was a hybrid tribunal where international judges and prosecutors and staff like myself work together with Bosnian and Herzegovinian prosecutors, judges, and staff to help them to prosecute war crimes, crimes against humanity, and genocide cases in their national courts. I clerked in the Southern District of New York right before I went to Boston.
I'm David Crane. I spent 30 years in various jobs in the U.S. federal government and was the Deputy Inspector General of the Department of Defense before I was called by Kofi Annan to go and start a new idea called the Hybrid International War Crimes Tribunal in West Africa in Freetown, Sierra Leone, which I did for 3 years. And then I came back, and now I teach what I did in my life at Syracuse University, and with a lot of good students. I helped found Impunity Watch, as well as the Syrian Accountability Project in 2012 with a group of high school students and Drew Bider and another good Syrian American friend. We established the I Am Syria campaign, which you can find on, which has really been an amazing effort, and mainly an educational organization, which I think from last count we had 13,000 teachers from around the world download our lesson plans on Syria and counting. And the students really run this website, and of course we help with the lesson plans, but they come up with these cool movies and stuff. So we've got a great movie for you. If you hit that, they produce something really special.
I'm Norman Farrell. Good afternoon. I'm started as a prosecutor in Canada for about 10 years, and then decided to leave criminal law for a short jaunt with the International Committee of the Red Cross, legal advisor in Bosnia, post-war, and East Africa, covering 3 or 4 countries in Africa as the ICRC's legal advisor. Then we'll have worked at the ICTR, the Rwanda Tribunal, the Yugoslav Tribunal, and now I'm the prosecutor at the Special Tribunal for Lebanon.
Well, gentlemen, thank you. I don't kill myself here. My job is just to process the panel and the questions, and we're going to go from high school question to a more collegiate question and in between. But the goal of this is to train the next generation, and to pass that torch that someone gave you. And Mr. Rapp, if I could just start off with a personal question for you. I know you work a lot with the Holocaust Museum in Washington, and all of you are familiar with Jackson. What is it about Jackson's message that you want to convey to this audience, and why is it that this law dialogues has become so popular? I sense it recharges your batteries, but what torch do you want to pass to this group of students that is Jacksonian?
Well, there are a couple things we remember of Jackson. One, it was the people that really do these crimes, the really big men. I mean, there are people involved on the ground that are doing bad things, but when you have mass atrocities, when you have 6 million Jews murdered, when you have 800,000 Rwandans, Tutsis murdered in 100 days, those are powerful men that are making the decision to do that. It's not wild people out just acting out ancient hatreds. It's motivated, it's organized, it's paid for. And what Jackson said at Nuremberg is that the common sense of mankind says that the law shouldn't stop with petty crimes by little people. It has to reach the men who possess themselves with great power.